I'm Neil Netanel. I'm a professor of law at the University of the UCLA School of Law. I teach and write about copyright law and international intellectual property. Copyright is a bundle of rights that are given to creators of original expression, largely exclusive rights to control certain uses in that expression. Principally, if the artist is a creator, the artist's principal way of getting money for the use of the artist's creative expression is through copyright, because through copyright no one else can make copies of or publicly perform, broadcast, or publicly distribute copies of the music without the composer's permission. Copyright, as I said, is a set of exclusive rights in original works. Although there are, I say exclusive rights, but there are some various exceptions and limitations on those exclusive rights. But principally, the exclusive rights are firstly the right to reproduce copies of the work, reproducing a copy would be in any manner or form, so it would either be in paper or making of a sound recording of a musical composition is the making of a copy of that musical composition. It includes the right to make derivative works of an original work, which would include the right to modify the work, remix the work. It includes the right of public performance, and public performance includes both live performance and also transmissions over the internet and broadcasting. It includes right of public display, which probably is more relevant to graphic works and maybe in some cases literary works than actual works of music. And it includes the right to distribute copies to the public, which is a separate, independent right from the right to reproduce copies of the work. First, let me say that as a condition to enjoying copyright, the composition has got to be fixed in a tangible means of medium of expression. So, if you think of a song in your head and you sing it, you perform it in a studio, or even live on stage, unless you've actually recorded it or written it down, it can be written down on sheet music, or it has to have been recorded, fixed in some tangible means of expression, it's not yet protected, and anybody could copy it at that point, at least as the composer. So, in any event, I would say all of those rights could be important for a musician. So the right to reproduce copies means that once your work is fixed, no one else can reproduce copies of your work. The right of public distribution means that no one can distribute copies of your work to the public. And public distribution has been defined also as allowing others to download copies of your work off of a computer. That's, of course, they define that as a public distribution. Nobody can broadcast your song over the radio or perform your song live without permission. Now, in practice, maybe this is getting ahead a bit, but in practice, most musicians have licensed or assigned at least part of those rights to other parties, maybe to a record label. ASCAP and BMI usually manage the public performance rights for most music. So when a radio station, for example, plays your music on the air, they generally do so under a license with ASCAP or BMI, which gives them the right to publicly perform your song. And they pay a certain percentage of their gross to ASCAP and ASCAP and BMI divvy it up to their various members in accordance with a sort of formula that they keep pretty much a secret. As far as the Copyright Act is concerned, the moment you have recorded it or written it down, the moment you've reduced it to tangible form, it is protected by copyright. You don't have to do anything else. Now, there are some things you probably should do. One is you should register the work with the U.S. Copyright Office. And there are various sort of procedural reasons for that. Principally, if anyone ever infringes your copyright, if they infringe it after you've registered, then you're entitled to sue for your attorney's fees and get what's called statutory damages. You don't have to actually prove how much their infringement has damaged you. If you actually get to litigation, those can be very important procedural advantages. But you don't have to do that in order to enjoy copyright. You enjoy copyright from the moment you've reduced it to a tangible means of expression. Another thing that some people do is that they'll make a they'll write down their song in sheet music, and they'll put it in an envelope and seal the envelope and send it to themselves by certified mail. That really has no legal import. The one thing it does do is it can serve as evidence that you wrote that song as of the date that it was sent to you. As long as you don't open the envelope, you got to keep it sealed. But that's just sort of if there's happens to be some argument about who wrote the song as of what date and who might have copied from whom, that can help as evidence of when you wrote the song. But it's not necessary. It doesn't, establish your copyright in what you've actually written. Generally, the music publisher governs the right to distribute copies of your work. And distributing and making copies, it's called the mechanical rights. Mechanical rights is making copies of your work. And the music publisher will often go out and try to find people that are interested in recording your song. And that may involve recording artists. It also may involve record labels. So the music publisher administers typically your mechanical rights. Now there is, then the record label, if you are also a recording artist and you want to record your song with the label, very often the labels also have music publishers that are affiliates. And sometimes if you don't already have a music publisher, the label's music publisher will then administer your mechanical rights. And then there's also a performing rights society, which includes principally ASCAP and BMI, and they administer the public performance rights, which includes both, as I mentioned earlier, rights to play your song over the radio, as well as live performances, and also the rights to play your song over the radio in retail establishments, bars, and restaurants. So, so I mentioned earlier that copyright is a bundle of exclusive rights, but that those exclusive rights are limited by certain exceptions and limitations. One of the important exceptions that many people have heard of is the exception of fair use. If someone falls within the category of fair use, then they are allowed to make use of your work without any payment to you and without having to ask your permission. But fair use is a fairly narrow exception, and it's difficult to predict ahead of time whether or not a use will be considered to be a fair use. Another limitation, though, to the exclusive right, which affects musicians across the board much more frequently, is what's called the compulsory license to record your song. If you've written a composition and your composition has already been recorded and released to the public, anyone else is entitled to make a cover recording, their own version of your song, and they don't have to ask your permission. What they do have to do is pay you the statutory rate set forth in the Copyright Act. And usually even those mechanicals are administered through the Harry Fox agency, which represents music publishers. Right, if your cover constitutes a fair use, then you don't have to get permission, you don't have to pay anything. It's very difficult to determine in advance whether a given use is going to be a fair use or not. Fair use is designed to be an equitable rule of reason that courts are supposed to decide on a case-by-case basis whether it's fair to allow someone to use your work without your permission. The Copyright Act sets forth 4 statutory factors that are supposed to serve as guidelines for the courts to consider in determining whether or not a given use is fair. And those factors aren't exclusive. The court can consider other factors as well. Those factors include, probably the most important of those 2 factors are, first of all, what is the nature of the use? If the use is transformative, such as if it's a parody or criticism, that tends to count in favor of fair use. And then the 4th factor is the effect of the use on the market for the work. If the work is going to substitute in the market for your work, if it would compete with your work, then that will count against fair use. Yeah, another exception to exclusive rights in musical works is under the Audio Home Recording Act. Under that act, consumers, individuals at home, are entitled to copy music so long as they use equipment that's dedicated for copying music. And the Act provides that no infringement claim can be filed against them for doing that. So that Act basically it came about with the advent of digital audio recorders. Those were being at some point in the 80s, those were being produced in Japan, and the producers of those devices wanted to sell them in the United States. The record labels are very concerned that if people bought digital audio recorders, they would use them to make perfect copies of songs, sound recordings, and that would really hurt the market for CDs. But it was uncertain whether, under existing precedents, whether using a digital audio recorder to make a home copy of a song would have been fair use or not. So in the face of the legal uncertainty, basically the various industries involved hammered out a compromise under which digital audio recorders and digital media, blank CDs, that are used to make copies, there's a levy imposed on them. And that money goes to pay the recording artist and the copyright owners. And digital audio recording equipment has to come with what's called serial copying management systems, which basically means consumers can't use them to make more than, I think it's 5 copies of a copy of a particular recording. And on top of that, the statute provides that copying music using that equipment is not an infringement of copyright. The Audio Home Recording Act, again, it was designed to address this problem of digital audio cassette recorders. And the computer industry actually did not want to have to pay a levy on the sale of computers and didn't want to have to equip computers with serial copy management systems that would limit the possibility of copying on the computers. So they lobbied hard to have computers excluded from the provisions of that act. So it's somewhat controversial, but pretty much accepted that if you copy music off the internet using a computer, that does not fall within the privilege of the Audio Home Recording Act. And today, of course, people use computers to copy music. They don't use digital audio cassettes. So pretty much, there's some minor exceptions, but pretty much the Audio Home Recording Act is a dead letter because the technology has moved much beyond that. So today, of course, the primary threat perceived by the recording industry is not from digital audio recorders, cassette recorders, rather through massive peer-to-peer copying of music over the internet using personal computers. I came to copyright law actually in a way unrelated to music. When I went to law school, I actually didn't even take copyright law. But my first job out of law school was working for a law firm as an associate, and I worked in the litigation department, and we represented the manufacturer of Pac-Man video games. And we sued video arcade owners who had counterfeit Pac-Man games in their video arcades. So it was actually a very rough assignment. I was sent to Hawaii for a month to sue video arcade owners that had counterfeit Pac-Man games in their video arcades. And at the time, actually, it was kind of at the cutting edge of copyright because we had to establish that there was copyright protection both in the underlying computer software for the games, but also in the audio-visual work that the user saw on the screen, even though the user had some control over how the work actually appeared. So we sort of, that series of litigation actually established the precedent that that was a protectable work. Well, I moved to Israel, and I practiced law in Israel for many years. And in Israel, I represented Israel's first cable television company and represented them in a number of both telecommunications and copyright matters. And I also participated as a consultant on a commission to revise Israel's copyright law, which at that time and still is actually the British copyright law of 1911. And became very, very, very interested in copyright. At the time, this is 20 years ago, copyright was still a relatively quiet backwater. And when I decided to go into academics, into teaching, Copyright was my primary field of interest. And it's really been just since I started teaching it that copyright has just exploded in terms of its reach, and now touches everyone's lives, at least to some extent. Of course, particularly musicians, but whom it's always touched. But consumers, because it's digital technology, it makes it possible for anyone with access to the internet to be both a voracious consumer of copyright protection, but also a creator, to be able to manipulate works and change them, and very, very cheaply and inexpensively create and distribute works. Yeah, there are a number of things. The record labels for a long time were very resistant to suing individual file sharers, people that use peer-to-peer systems to copy music off the internet. But within the last couple of years, they have begun to sue individuals, and a number of courts. One court has recently held directly. Other courts have suggested that trading files over the internet is an infringement of copyright. The record labels have also sued the providers of software that is used to trade files over the net. They successfully have sued Napster and Grokster, for example. And then thirdly, this hasn't really taken full force yet, but the industry is planning to the extent possible, to encrypt music with digital encryption to make it much more difficult for people to copy. So that's the industry, what the steps the industry has taken. I, along with many other observers, are skeptical about whether or not any of those steps will really be effective. So far, at least, despite several thousand lawsuits against individuals and successful actions against suppliers of software that individuals use to trade files, all the indications are that, at least worldwide, unlicensed file sharing not only continues unabated, but continues to grow steadily. So I think it's very difficult to stop unlicensed peer-to-peer file trading. And my impression is that this is true with the movie industry as well as the music industry, that their primary hope is just to try to keep unlicensed file sharing within sort of acceptable numbers, and at the same time to develop some kind of licensed downloading, such as through iTunes, to at least establish some market for that. But as observers know, at least at this point in time, February 2006, that whole area is very much in flux, and there are a lot of uncertainties involved in this whole area of peer-to-peer file sharing. My thought is that there are no good solutions to peer-to-peer file trading. Let me just qualify that. When I say there are no good solutions, I am one also of many observers who believe that, except for the fact that musicians aren't paid and copyright owners are not paid by unlicensed peer-to-peer file trading, the technology and the practice is a very good one. It's a very efficient way for people to get access to music. And people get access to music that is not commercially available. Even the best of the licensed sites, such as iTunes, even the labels can only clear the rights to a fraction of the music that's available, so there's much more music available on peer-to-peer. There are very, very creative mashups and remixes that people release through peer-to-peer that would not otherwise be available. In other areas aside from music, there's now a whole new art form called machinima, which is people using video game platforms to create animated short motion pictures, which are being released through peer-to-peer file trading. So I think as a principle, this decentralized mechanism for distributing cultural works and creative works is really very good for culture, and ultimately very good for artists who want to get their work out there. So I think it's, from a public policy standpoint, and the point that ultimately I think serves most musicians, we want to try to find some way for musicians to get paid, and get paid in line with what is the consumer demand for their works. but still allow there to be peer-to-peer file trading. So I think the best way to do that is through borrowing from the Audio Home Recording Act and imposing a levy on the services and products that people use to trade files. Because after all, the value of those products and services are really enhanced by the fact that people can use them for trading music. People will have more of a demand for computers and more of a demand for MP3 players, more of a demand for iPods, because they're able to put a lot of free music on those iPods. So I think it's only equitable that companies that supply those services, and then that should also include broadband internet service, which people use to download music. Suppliers of those goods and services, those products and services, should have to pay some levy. That money would be collected and then distributed to holders of rights in music, depending on how the percentage of their works that are actually available for download, and that can be tracked already through companies like Big Champagne that are able to determine which songs are most available for download, and really do that with much greater precision than ASCAP has traditionally done it for radio. So there are highly effective sampling techniques for determining what is the consumer demand over these networks. So although there are problems with this is not a perfect solution, but there are no perfect solutions to this. I think the way the record labels are going is to try to look to remedies that are simply not going to be effective. So I think the levies are something which are worthy of serious consideration. I should say that the French Parliament, the lower house, has just passed a bill that would enact a levy system in France. Now, it's not clear if this is actually going to be enacted into law because it still has to be passed by the upper house, if I understand correctly. But very surprisingly, even in France, which is sort of a country known for its almost religious protection of authors' rights, the lower house enacted a bill that would allow free, unhindered at least, peer-to-peer trading of music in return for imposing a levy on, I think it's on internet service and computers, and that money would go to compensate the rights holders. The equipment and services that are provided in a particular country would be levied in that country, and then the uses of the works, the downloading would be tracked in that country, and the funds would be distributed in that country in percentage of the consumer demand for those works. And in line with, this happens with ASCAP and BMI already, there are agreements where if an American song is played on French radio, the French collecting societies collect the royalties for that song and distribute it to the holders of the rights in the composition in the United States. And the same thing would happen with peer-to-peer file trading. I suspect that most of, certainly if I'm a supplier of the equipment or service, I would try to pass as much of it as I can on to consumers. In a competitive market, I probably won't be able to pass all of it on, but I probably will pass some of it on. But consumers, of course, many consumers would love to receive music for free and have as much as they want. If they had their druthers, that's what they would do, at least in the short term. But in the long term, there might be less and less music created unless there's some mechanism for compensating the creators. So I think that the proposal of the levy would not be anybody's first choice. Consumers would love to get music for free without paying for it. The record labels would love to have perfect control of their songs, so no one could use them at all unless they got their permission, and they could charge whatever price they insisted on. Musicians and artists, I think, sort of fall somewhere in between. Some are very happy to have the publicity that peer-to-peer file sharing enables them. Probably artists that are already successful would rather, they're more kind of in line with the record labels, would rather have complete control. And of course, the providers of goods and services that people use to trade files would love just to have the situation be that their products are rendered more valuable and therefore they can charge more money for them because people use them to trade files without having to pay this levy. But I think the second best solution for everybody, when you put it all together, if we want to still continue to have some compensation for creators and the intermediaries as well, the labels as well, who perform valuable services, it's equitable to impose this levy on all goods and services that are rendered more valuable because people are using them to trade music. I did do some estimates, and these can only be estimates, based on an estimate that at least at this point in time, and I think let me just back off and say that there have been a number of studies that have looked at to what extent, as of today, has unlicensed peer-to-peer file trading harmed the music industry. And those estimates range from not at all. And it's got to be remembered that the vast majority of files that are traded do not substitute for sales of record albums. Firstly, people download individual songs, and secondly, the average teenager who might have $10,000 worth of free music on his iPod doesn't have $10,000 to spend buying the music. So a lot of the music that's traded and downloaded, the recording industry often doesn't say this, but it's really the case, doesn't substitute for it's not a lost sale. It really is just increased exposure for the artist, and if anything, might engender increased sales for CDs. But having said that, so the studies range from file trading so far has not hurt the industry at all to maybe harm the industry about decreasing 20-25% of its sales. So based on those figures, and I looked at what are the gross sales of a whole series of consumer electronics products that people use to trade files, that an average of about between 4 and 4.5% levy on those goods and services would be sufficient to compensate the record labels for the harm caused to them by file trading.
Incredible. So little.
Yeah, it's really fairly marginal when you think about it's less than sales tax in most states. There are administrative costs involved in this system at all. I mean, this would require hearings before a Copyright Office arbitrator or somebody to determine which products and services have to pay the levy, how much of the levy each would have to pay. I think that should be calibrated roughly into how much value is enhanced for each product and service by peer-to-peer file trading. For example, computers have many, many other uses aside from file trading. So they should probably bear a relatively lower burden than MP3 players, which are a repository of many, many unlicensed music files. And then the administrative body would also have to determine what is the overall amount that has to be paid, reach some kind of determination of what is a fair return for the industries that are affected, and then also would have to divvy up the proceeds to the various rights holders. And as I said, in France, this proposal has been treated seriously enough, and I was actually asked by someone in France I've written an article about this and to send them my article, so I did, and so it's gotten to someone, I don't know to who exactly. In the United States, there has been some interest, but I think at this point, we're still at a stage in which the entertainment industries are fighting tooth and nail for some kind of control. They don't want to give up their proprietary right, the right to try to set prices and the right to refuse to allow anyone to use their work without their permission. And no one on the consumer electronics side wants to have to pay this levy. And the consumers, meantime, those who use peer-to-peer file trading services are relatively unthreatened. There have been several thousand lawsuits, but that's a drop in the bucket compared to the millions of people that use these services. So at this point, I think everybody's hoping that they can kind of get it their way. So although the idea has been considered by all sides to some extent, and by the Copyright Office as well. The Copyright Office issued a report about copyright in the digital age and sort of had a short discussion of this levy as well. At this point, I think it's just sort of hasn't yet been taken up by anyone. I think if it ever is going to be taken up, the situation is going to have to get a lot worse for everyone, and I think everyone's going to have to feel that they have something to lose if they don't adopt such a proposal. The DMCA protects the integrity of digital encryption So the record labels, well, some of them have begun to do this. Sony recently, it blew up in their face. They encrypted CDs, and it turned out that their encryption was basically a spyware program that was sort of taking over people's computers. That's a bit of an exaggeration, but it was really opening up a window that would enable other people to hack into computers of people that had inserted these encrypted CDs in their computers. So Sony had to withdraw the product. But nevertheless, the record labels are hoping that at some point they can encrypt CDs and make it much more difficult for people to copy the CDs without their permission, similar to what's done on DVDs that motion picture studios issue. Now, the problem with that is that any hacker worth his salt in pretty short time is able to find software that would, and develop software that would circumvent encryption on CDs and also DVDs. So in 1998, the industry, realizing that this would be a possibility, lobbied Congress for an amendment to the Copyright Act that makes it illegal for anyone to market software or other products that people can use to circumvent encryption that the industry puts on CDs or DVDs. It also makes it illegal to circumvent encryption that's used to control access to existing works, although not to copy existing works. So that is a law in the books. It's not clear ultimately how enforceable that would be, because just like with the content itself, once someone does circumvent the encryption and post that on the internet, everyone has it. And that's happened with DVDs, right? DVDs are encrypted with software called CSS, and someone developed software called DCSS, which circumvents CSS. And DCSS is available widely. Lots of websites pop up, and mostly in foreign countries. And people can download software that enables them to circumvent the copy controls on DVDs and write their own copies. So there is an enforcement problem there. And there's also just the consumer acceptance problem. Will people seem to have accepted it largely for DVDs, but will they accept it for music? That kind of encryption. My sense is that what the entertainment industries are hoping to accomplish with encryption is just to make it difficult enough so that the average consumer is willing to pay the money to buy the encrypted copy, and then not be able to distribute it onwards, even if there continues to be peer-to-peer file trading that's unlicensed. As long as there's that's sufficiently marginalized and there's a large enough legitimate market. That's what they're hoping for. Yeah, I think Creative Commons, is a great idea, and and not only a great idea, but I think it's working very, very well for those artists that are interested in that. Creative Commons is a way for artists who want their work to be freely available, but want to place some restrictions on that. Maybe they don't want someone else to commercially exploit their work, or they want to make sure that they continue to have authorship credit for their work. So it's a way for them to use copyright law in order to maintain the openness of the use of their work, but with certain restrictions. So what they do is they distribute their work with a Creative Commons license. It's sort of an announcement to the world that they won't sue anyone for copyright infringement so long as people use the work in accordance with that Creative Commons license. The typical license, there are various possibilities for license, but the typical license is, right, you can copy my work as much as you want to, as long as you give me authorship credit. Some people allow others to modify their work and some don't. Some people say you can't make money off of my work unless you get my permission, but you're free to distribute it non-commercially. If you work with someone else to write a song, and it could be you write the music and someone else writes the words, or you both collaborate in writing the music, but if you work together and you intend to create this single work together, you're both considered to be co-authors of the song. And each of you has an undivided, if there are two of you, has an undivided interest in the entire song. So even if one person contributed 90% and the other person contributed 10%, each person has a complete undivided interest that you share in that song. And under U.S. law, either of you can license the use of that song to anyone else without having to ask the co-author's permission. The sole condition to that is if you've got to pay the other person their share of the royalties, but you don't need the permission to do that. So that's a very important point to keep in mind when you collaborate with other people. A work for hire is a work that is either created by someone as part of their employment, in which case the employer owns the copyright and not the actual creator. Or in some cases, if someone commissions a work for use in certain kind of works. The Copyright Act lists 9 categories of works that can qualify as a work for hire for commissioned work. A sound recording is not one of them. Was for a time, and that got repealed from the Copyright Act. But it can be a collective work, which is a sort of anthology. It could be a motion picture. So if someone commissions you to write music for a motion picture, let's say, and there's a writing that says this is a work for hire, the person who commissions you is the author and owns the copyright, not you. And you're not a joint author. It's the commissioning party that is the author in that case, if it's a work for hire, not the actual creator. Co-authors can do that, right? So if someone collaborates with you in writing a song, and the arrangement is that you're going to be the sole author, not them, they could assign to you whatever rights they have. But that's got to be in writing. In order for a copyright assignment to be effective, it has got to be in writing, signed by the person who's assigning the copyright. The digital use of music, which includes downloading, sort of where the end user ends up with a copy, and streaming, where the end user just hears the song but does not make a permanent copy, implicate a whole set of issues in copyright law which are very, very complex. First, let me say, we've been talking just about the music composition, but it's important to point out that a sound recording of a music composition or of anything else under copyright law is a separate, distinct, copyrightable work. So for example, if I go to the beach and I make a sound recording of the waves crashing on the shore, I have a copyright in my sound recording. That is an independent copyrightable work. The same thing is if I make a sound recording of a musician performing a composition in a studio. The composer has a copyright in the original musical composition, but the recording engineer has a copyright in the sound recording. That's a separate, independent, copyrightable work. Now, when someone records for a label, usually this is all worked out by contract, and the label will own the copyright in the sound recording, and usually it's the composer that retains the copyright in the musical composition. But again, at least by law, these are 2 separate, distinct works. And the mechanical license, right, whereas if someone can make a cover recording of a previously recorded song, only is a compulsory license for the musical composition. Someone who wants to make an exact copy of a sound recording still has to get permission of the owner of the copyright in the sound recording. So in the digital arena, if I want to set up a website, let's say, and I want to download sound recordings, I've got to get permission from the owner of the copyright in the sound recordings in order to do that. Under the Copyright Act, I do not have to get permission from the owner of the rights in the musical composition, because that falls within the compulsory license for mechanicals. Right? It's considered to be a digital phonorecord delivery, which falls within the ambit of the cover recording exception. If I'm webcasting, if I'm streaming sound recordings over the internet, there's a whole other series of very complicated provisions of the Copyright Act that apply. That may or may not fall within a statutory license for the sound recording. Depends on the nature of my webcasting. With respect to the musical composition, I will have to get permission, but those rights are generally administered by ASCAP or BMI or another collective licensing society. Yeah, with digital technology, one creative tool that is increasingly used by many musicians and recording engineers is sampling, is taking existing recordings and copying directly snippets of those recordings and then manipulating them, changing them, and inserting them in new original soundtracks, right? Practice